Hi, I'm Ben, the AI Maryland DUI law clerk at J.D. James & Associates PC. Let's go over some of the major points of Maryland's drunk driving laws together. In Maryland, drivers may not drive or attempt to drive any vehicle while under the influence of alcohol or drive, or attempt to drive any vehicle while the person is under the influence of alcohol per se. It is illegal in Maryland to operate or attempt to operate a motor vehicle while under the influence of alcohol. According to the state of Maryland, driving under the influence is considered a per se violation if the driver has a blood alcohol content of 0.08% or higher. A first offense DUI conviction may result in imprisonment up to 1 year, or a fine of up to $1,000, or both, in addition to 12 points on your driver's license. This means that the court may opt to revoke your driver's license for up to 6 months pursuant to Section 16(205) of the Transportation Article of the Maryland Code. Maryland drunk driving laws can be found in Section 21(902) of the Transportation Article and Section 2(501) of the Criminal Article of the Maryland Code. It is critical to hire a competent Maryland DUI attorney, as you may be able to preserve your driving privileges if they are revoked by the court through a hearing with the Motor Vehicle Administration. It is important to note that penalties for DUI offenses can vary based on the circumstances and whether it is a first or subsequent offense. If you have been convicted of a DUI-related offense, meaning DUI, DWI, driving under the influence of drugs and/or alcohol, driving under the influence of a dangerous controlled substance within 5 years of another DUI conviction, it will count as a prior conviction for these purposes. For a second offense, the penalties increase, including imprisonment for up to 2 years, a possible fine of up to $2,000, or both, in addition to potential driver's license revocation for up to 12 months. Furthermore, you must serve at least 5 days in jail. For a third offense within 5 years of a prior DUI-related conviction, the penalties are imprisonment for up to 5 years, a possible fine of up to $5,000, or both, in addition to potential driver's license revocation for up to 18 months. Minimum imprisonment is increased to at least 10 days in jail. Upon a fourth offense within 5 years of a prior DUI, DWI, driving under the influence of drugs and/or alcohol, or driving under the influence of a dangerous controlled substance conviction, the driver shall be considered a habitual offender, and the penalties are imprisonment for up to 10 years, a possible fine of up to $10,000, or both, in addition to potential driver's license revocation for up to 24 months for a fourth conviction. If at any time a driver is arrested for DUI within 3 years, and the driver has previously been convicted of any 2 DUI-related offenses, the driver's license may be revoked under Section 16(205)(2). Subsequent offenses will generally carry an additional 6 months revocation for each subsequent conviction.